Hello and welcome to Bright Contracts. In this video we'll briefly look at why your organisation needs to have employee documentation in place. We understand that many employers are apprehensive about rolling out contracts of employment, particularly to existing staff members. Some employers feel it will restrict them in how they manage their employees, whilst others feel that contracts will create a level of distrust between employees and management. In actual fact, the truth is that not having contracts of employment in place is harming to a business. So let's look at why.
First and foremost, it is a legal requirement that all workers, whether full-time, part-time, temporary or casual, receive a written statement of their terms and conditions of employment. There are specific details that must be included in these written terms, and they are set out under the Employment Rights Act of 1996. However, in addition to the legal requirement, having contracts in place also offers increased protection to employers. Let's look at some examples. For employers who do not have their own contracts in place, default employment law will apply to employees. The issue with this is that the default employment law is generally weighted towards the employee, not the employer. For example, take the issue of notice periods. Statutory notice requires that employees with over 1 month's service must give their employers just 1 week's notice of their intention to leave. This means that if you have a long-serving vital member of staff, they could decide to leave, giving you only 1 week's notice. This would leave you with very little time to find a replacement or organise any form of handover. But by issuing a contract, however, employers can set out increased contractual notice, thus protecting themselves from losing important staff with very little notice. In addition to compulsory statutory clauses, employers can include extra terms in the contract, which will offer them further protection. For example, confidentiality clauses, preventing employees from publicly disclosing confidential information. Restrictive covenant clauses are also quite popular, and these place reasonable restrictions on employees upon termination regarding working for competitors or contacting company customers for a period after they leave. Pay in lieu of notice clauses and garden leave clauses are also popular. Contracts of employment can also give clarity and reduce confusion. In the absence of written terms, implied terms and conditions can exist. Therefore, employers can rely upon custom and practice. Where custom and practice exists, problems can occur when the employer and the employee disagree with regards to what the terms are. This is particularly relevant around additional benefits and what people are entitled to. Clearly stating what is available to staff can prevent many disagreements.
So as we've seen, there really is no advantage of not having contracts of employment in place. If you have any questions or wish to learn more about Bright Contracts, please don't hesitate to contact us.